Wills Made Simple, the Complete Bridelawyer Guide, Part 2. What happens if you die without a will? Bridelawyer explains intestacy and scenarios where you absolutely should have one. Hi friends, welcome back. I'm Morgan Weil, co-founder of Bridelawyer, and today we are diving into something that sounds pretty boring, but is secretly one of the most dramatic topics ever. We are talking about what actually happens if you do not have a will. And if you think your family dynamics are messy, just wait until the law gets involved. Today's episode is the plot twist episode of this series, because the truth is, people assume everything will just work itself out if they pass away without a will. Guess what? It does not work itself out. It becomes paperwork, chaos, conflict, emotion, fighting, and decisions made by the court that have never met you. And you think those TV shows where the family is fighting over a will are crazy? Wait until you see the reality in families where there is no will. So let's get into this simply, clearly, and without shame. Because remember, you're not supposed to know this stuff. That's why I'm here. So, what intestate really means? When someone dies without a will, the law calls that intestate. And let me clear up what it doesn't mean, because people get wild ideas. It does not mean your parents automatically get to barge in and clean out your apartment. It doesn't mean your boyfriends can just grab your jewelry. Your landlord gets your furniture. Your cousin Tina can swoop in and say she wanted me to have the lamp. Nope, none of those things are true. When you die without a will, the law steps in with a very strict set of rules that determine who gets your assets, who has the legal right to claim them, who can access your accounts, who can deal with your home, car, debts, money, and personal items. And the process is way more complicated than people even imagine. People think dying without a will means my family will just divide things nicely. Absolutely not. And here's a real example. We once saw two siblings fight for 6 months over who should handle the estate, even though it was mostly IKEA furniture and a 2009 Subaru. It's never about the stuff. It's about the power. First step, the death certificate. Before anyone can touch anything, your bank accounts, your home, your car, even your mail, someone has to obtain a death certificate from a city or town official. This is the official proof that a person has passed. Without a death certificate, the bank won't speak to you. They just won't. The insurance company won't answer. The credit card company won't close the account. The mortgage company won't adjust anything. And the courts cannot begin probate. It is literally the key that unlocks or locks everything. And guess what? They don't process it right away. It may take 10 days or 2 weeks to get one. If you don't have a will, the court chooses an administrator. When you do have a will, the person you choose to handle everything is called your executor. But with no will, the court chooses someone for you. That person is called an administrator. Here's how that works. Step 1. Someone files a petition with the court. Usually a relative, sometimes a friend, occasionally someone you barely know. Files paperwork saying, "Hey court, someone needs to handle this. I volunteer as tribute." If no one volunteers, it becomes a problem. A big problem, which we'll talk about in a moment. Step 2, all known relatives and interested parties are notified. This includes siblings, parents, adult children, estranged relatives, people who co-own property with you, and yes, sometimes creditors. So think about that. Even the people you haven't spoken to in a decade or don't want to speak to, get a letter saying, want to object to this person being in charge of the estate? Step 3, anyone can object. And this is where the drama begins. This is the Real Housewives of Probate Court. People can't object because I don't trust him. She's irresponsible. He just wants the money. She shouldn't be in charge of mom's accounts. That's not what our family wants. If no one objects, things move forward. If people do object, buckle up. It becomes a full-blown legal battle. Expensive, emotional, slow. Step 4, if no one comes forward, this happens more than people realize. If literally no one applies to be an administrator, the court may appoint someone, or maybe they don't if the state is small or nobody cares. In some cases, your money might actually just go to the state. Every state has a unclaimed funds office. Your checking accounts, savings accounts, security deposits, ancient bonds your grandmother bought you, the Starbucks gift card balance on your Apple Wallet, all of it eventually ends up sitting with the state until someone can prove they are entitled to it. And without a will, proving entitlement is hard. It's a pain even if you do have a will and an executor. Without it, we are talking about massive red tape. It's exhausting and just time-consuming. Letters of administration. Once the court approves an administrator, they issue a document called Letters of Administration. That gives the administrator legal authority to contact banks, access accounts, open an estate account, transfer property, deal with safety deposit box, and claim life insurance, sell or distribute assets, pay debts and taxes, and eventually divide what's left without these letters. Banks and institutions will not speak to you. Title companies will not change deeds. There is no access, so nothing can happen until these letters are issued, which often takes months. Don't put it off. Often you'll need to make an appointment in advance, even like 3 weeks in advance, just to have a sit down. Then you might have to wait for a final appointment and then wait to get the actual document. It's very time consuming. What the administrator must do once they are appointed. The administrator basically becomes the CEO of your entire life. They have to locate every asset you own, value everything, find every account, every investment, every insurance policy, deal with your mortgage, your credit cards, your loans, pay taxes, store, sell your belongings, contact the relatives, distribute everything according to the laws that they must follow, the state's rules, not your wishes. It is a massive job, and the person doing it may not be someone you would ever choose, or even someone you don't know. They may not know what you have or even where to look. Basic intestacy rules in most states. Each state is different, but generally intestacy follows a clear pattern. 1. Married with no kids means everything goes to your spouse. 2. Married with kids from a prior relationships means your spouse and your kids share things. Most people do not want this. It creates chaos. Imagine having a scenario where your new husband is sharing ownership of the beach house with your kids from a prior marriage. It happens very often. 3. Unmarried, no kids means everything goes to your parents, even if you haven't spoken in years. One parent is not a part of your life. Your parents are financially secure and don't need your money. And you would rather leave things to siblings or friends. 4. No spouse, parents, or kids means siblings inherit. 5. No siblings means cousins, second cousins, third cousins, people you didn't even know existed. One family discovered a half-sibling they never even knew existed, and legally, he was entitled to inherit just as much as they were. Intestacy doesn't care about relationships, only the bloodline chart. The big twist: class-based distribution. If even one parent is alive, they inherit everything before siblings get anything. So if your mother passed years ago, but your estranged father is alive, your siblings get 0. That man you detest gets it all. Family relationships mean nothing to the law. Only the bloodline chart matters. What this looks like in real life. Let's say you remarried, own a house with your partner, and both have 2 children from your previous marriage. If you die without a will, if you owned it as a joint tenant, your spouse might suddenly co-own the house where you 2 lived with your kids from the first marriage. So imagine the tension there. Your spouse wants to keep the home. Your son wants to sell to get his inheritance. Your daughter wants her share immediately, and the mortgage still needs paying. Your spouse is grieving, and now navigating lawyers, refinancing, buyouts, and negotiations, all because you didn't have a will. And this situation is very common. One family couldn't access their daughter's laptop or phone for months because no one had the legal authority. They couldn't get to her photos, banking, anything, all because there was no will. Then there is the surprise sibling issue. This one blows people's minds. Mine too. If your father had a child outside his marriage and your state law recognizes that child, that half-sibling can legally inherit from your estate. Even if you've never met them, you didn't know they existed, you wouldn't want them involved. New York and New Jersey have laws about establishing paternity, which might not be an issue until someone dies and that person wants to inherit something from someone. Meaning that DNA testing, birth records, or acknowledgement can legally insert a surprise heir into your estate. This is real, this happens, and a will prevents it. New Jersey and New York works. Let's go rapid fire through some of them. New Jersey. New Jersey has inheritance tax. People are separated into classes. Class A, spouses, kids, parents, no tax. Class C and D, siblings, nieces, nephews, friends, unmarried partners, heavily taxed. New Jersey probate is separate from New Jersey tax, meaning even a simple estate may owe taxes. New Jersey recognizes afterborn or posthumous children conceived before death as heirs. New York now. No inheritance tax, but a complicated estate tax, strict will execution rules. Many wills failed for technical reasons. Unmarried partners inherit nothing without a will, no matter how long you've lived together. Non-marital children can inherit if paternity is established even after death. Living with someone for 20 years in New York does not give them any inheritance rights. A will can. Common situations where you absolutely need a will. Now, let's get into real-life bride-lawyer scenarios. These are the situations we constantly see. Number 1, the newly married bride. She may have savings, inheritance, inherited jewelry, sentimental items, property with a parent, a car her father helped her buy, investment accounts. On day 1 of marriage, intestacy says everything goes to her spouse. But she may want family jewelry to stay in her family, her college savings to go to the parent who sacrificed for her all those years, her share of the family home to stay with her parents or siblings. A will makes that possible. Number 2, the bride with sentimental sibling attachments. Maybe her spouse is amazing, but doesn't love her little sister. She knows, if I don't write this down, my sister may never get the things that matter to us. So, a will protects those relationships and those memories. 3, the bride who owns property with her parents, common in New Jersey and New York, where parents help kids buy. Without a will, the spouse could suddenly co-own the home with her parent, which may force a sale, strain the relationship, create legal tension, erase the family's intention. A will ensures her share goes exactly where she intended. 4, second marriages. This is one of the biggest areas of disaster. People in second marriages often have adult children, retirement accounts, homes from previous marriages, sentimental heirlooms. Most want their biological children to inherit their assets, not their new spouse. Without a will, the spouse and children might have to share. The children might get nothing in certain states, and family conflict skyrockets. 5, professionals who own a practice, like doctors, lawyers, dentists. Listen up. In most states, your spouse cannot own or run your practice if they are not licensed, meaning they cannot sign checks, they cannot see patients, they cannot legally manage the business if you die. Your practice might shut down instantly, lose value overnight, be forced into a fire sale. A will, combined with proper planning, makes sure someone can step in long enough to sell or transition it properly. 6, small business owners. If you die, no one can pay employees, no one can pay rent, no one can pay vendors, no one can access business accounts. Everything freezes. A will ensures someone can step in immediately so the business can survive long enough to transition or close properly. Additional high-risk scenarios you should cover as requested. Here are some additional situations where a will is crucial. 7, pet owners. Legally, pets are property. I know it's hard to believe, but it's true about your baby, but it is. Without a will, they may go to someone who can't care for them or someone who doesn't want them. It will let you choose who takes them and can even leave money for their care. 8, unmarried couples. This is huge. Without a will, unmarried partners get nothing, no matter how long you've lived together, no matter how committed, no matter if you bought things together. You must write it down. 9, elderly parents you support. If you help care for or support a parent, you may want part of your estate to go to them. Intestacy might skip them entirely, depending on family structure. 10, people with complicated finances multiply in multiple accounts, multiple properties, or properties with multiple owners. Joint accounts. People who have trusts often need backup wills in case property wasn't properly titled in the trust. A will helps tie everything together clearly. 11, estranged family members. If there is someone you do not want inheriting from you, a will is the only way to ensure they don't. 12, people who travel frequently. Accidents happen. illness happens, and international procedures are even more complicated. Anyone who travels benefits from a clear will. So this is the end of part 2, and that wraps up our part 2 of our series. I know today's episode was intense, but it also empowering because now you understand what really happens without a will. And more importantly, you understand why leaving things to the default rules usually creates a lot of stress, chaos, and conflict for the people you love most. In part 3, we're going to take everything you've learned and show you how to actually make a will clearly, calmly, and without stress. We will walk step by step through mental capacity, witnesses, notarization, choosing your executor, choosing guardians, and how wills and trusts actually work. I'm Morgan from Bridelawyer, and trust me, you are doing something incredibly meaningful by learning this.